Hello friends, welcome to my channel. This is Mayank Shah, practicing company secretary based on Ahmedabad and majorly dealing into the corporate litigation matters. This video is in a continuation of my earlier video, which is with regards to the Jurisdiction of Tribunal under the Companies Act, where we have gone through two sections, that is section 7 subsection 7 and section 48(2). Section 7 subsection 7, which is prescribes that wherever company got incorporated by furnishing false information, then you can make an application. Second, wherever the shareholders agreed with the variation in the shareholders' rights, then requisite shareholders make an application before the tribunal to get the variation cancelled. Now, let's go for another section where the jurisdiction of tribunal is vested, that is section 55. Section 55, it's all about the issue of redeemable preference shares, because no company can issue the irredeemable preference shares, in which section 55 subsection 3 states that wherever a company is in a position where a company is not able to redeem its preference shares which is due for the redemption, or is not in a position to pay the dividend which are due on the preference shares, then in such a situation, such preference shares are called as an unredeemed preference shares. The company may issue the further redeemable preference shares in place of redeemed preference shares with the same terms and conditions equal to the value which are due for the redemptions and the dividend which are due on such preference shares. But before such issue of further redeemable preference, company needs to require to take the approval of first equity shareholders, because at the time of issue of redeemable preference shares, company has taken the approval of the equity shareholders by passing the special resolution. So when the company wants to issue further redeemable preference, needs to require to take the approval of equity shareholders by passing the special resolution. Second, companies also needs to require to take the approval of preference shareholders holding 3/4 of the value of preference shares. Third, not only that, the company needs to require to get the confirmation of the tribunal for the issue of further preference shares in place of redeemed preference, in place of preference shares which are due for the redemption. Now, so where there is also provided that the tribunal, by dealing with such a case, should confirm that the preference shareholders who have not given consent and who are agreed with the issue of further preference shares, they should be redeemed immediately. Then and then tribunal should give the confirmation, else the company not in a position to issue the further redeemed preference shares, and company is required to redeem the preference shares. Now, the manner in which the application can be made, in which manner the company can make an application, let's go for that. The rule under the NCLT where the company can make an application, and that is Rule 69. Rule 69, Sub-Rule 1, where it has been provided that where the company wants to make an application under section 55(3), then the format is NCLT 1. But here, what the annexures that are supposed to be made, and that is in this case NCLT 1, along with that the particulars of the registration document, MOA, AOA, certificate of incorporation, along with that the terms on which the preference shares are earlier issued, the redemption amount, the where it has been due for the redemption, the whatever dividend which has been due for the payment, along with that the terms on which the company is proposed to issue further redeemable preference shares, along with that special resolution copy of by which the shareholders equity shareholders approval has been taken, along with that the minutes of the preference shareholders meeting where the preference shareholders consent has been taken, along with the details of preference shareholders who have given the votes, along with the details of preference shareholders who have not given their votes, audited balance sheets of 3 years, so that it can be identified the company's position, whether company is in a such situation not able to pay or only trying to get the extension. So for that also 3 years audited financial statements, along with that the mandatory drafts which are supposed to be annexed with the application, that are notice of admissions, affidavit verifying application, memorandum of appearance, synopsis, list of dates and events, such drafts. Now, on a perusing of the documents at the first hearing, NCLT have give the direction to serve the notice to respondents, and after serving the notice, after hearing both the parties, pass an order, and that is confirm the issue of further preference. But at the time of confirmation, passing an order, the tribunal should confirm that the preference holders who have not consented should be redeemed immediately. So this is the manner of application through which the application can be made to the tribunal. Now the case law. Here the case law is, एक केस में ऐसा हुआ था, the company, in order to issue the further preference shares in place of preference shares which are due for the redemption, the company has taken the approval of equity shareholders as in ordinary case it required to taken, and on such a ground, on such a approval, the company has issued the preference shares. The company has not taken the approval of preference shareholders and all this stuff, and not taken the confirmation of tribunal. So with the shareholders agreed with the procedure which the company has followed. The preference shareholders make an application. Some of the preference shareholders make an application to the tribunal which are holding less than 3/4 of the value, even which is not required, because the 3/4 requisite is for the approval of issue of further preference shares. Is not for the to make an application. Anyone can make an application. There is no requirement which has been prescribed. Even the company here is need to require to make an application, but company has not made an application. So some of the preference holders have made an application before the NCLT Chennai bench. NCLT Chennai bench has dismissed the application on the grounds that the preference holders who have moved before the tribunal have no locus standi to make an application under section 55(3), or such preference holders have no locus standi even to make an application under section 245. The preference holders have also quoted the section 245. So NCLT has dismissed the application. The preference holders, and where the company has contended that the preference holders have no locus standi because preference holders does not hold the requisite value of the preference which has been prescribed under section 55(3). The said preference holders moved before the NCLT, and where NCLT has reviewed the case, has reviewed the provisions of section 55(3) and has clarified that and has directed the NCLT Chennai bench that section 55(3), where whenever it has been prescribed that whenever a company wants to issue the further redeemable preference shares, the company needs to require to take the approval of preference holders which are holding 3/4 of the value of preference shares. So it is the prerequisite of the issue of redeemable preference shares which the company has not taken, not followed. Second, company needs to require to take the approval of tribunal for the same, and company has not taken in this case. And even if the company has taken the approval of 3/4 of preference holder, 3/4 of the value of the preference shares, second, it also take the confirmation. But while confirming, the tribunal should also consider in a view that the preference shareholders which are not agreed with the issue of redeemable preference shares, whether they are redeemed or not immediately. So even which has been prescribed under the legislation 55(3), even the NCLT has clarified that even it has been not prescribed under the legislation that the preference holders who have not aggrieved should immediately, but even that preference holders which are aggrieved and where it has company has not redeemed such preference holders, they can also make an application even though the same has not been prescribed under legislation under the justified ground, on justice basis, under the common rule of NCLT, that is rule 11 of the NCLT. Not only that, the tribunal had also clarified that even the said preference shareholders can also make an application under section 240Y, because the preference shareholders is also considered as a member under the Companies Act and have the valid rights to make an application. So this is whole the case. Here we learn that wherever the company wants to redeem the preference shares, whenever the company wants to issue the further redeemable preference shares in a place of preference shares which are due for the redemption, then in such a case company needs to require to take the approval of preference holders which are holding 3/4 of the value of preference shares. Company needs to require to take the approval of confirmation from tribunal, and in between the way the preference holders who are not agree with the further preference share, issue of redeemable preference shares, such preference holder redeemed immediately. Then and then the tribunal should approve, else the tribunal give the direction to the company to redeem the first of preference shares which are not agreed with the same. So this is whole the case where jurisdiction lies, and this can also be the case of 245 class action suit if preference holders which are agreed with the same and not redeemed immediately. So this can also be the case of where the jurisdiction lies to the tribunal. Let's go for another section. Another section is section 58. As we are aware about that, section 58 is all about refusal to register the transfer of securities or transmission of securities. Wherever in case of private company there is a restriction, that is there is a maximum limit of number of members. In case of public company, the shares are freely transferable, securities are freely transferable. So in case if company is refusing to register the securities of transfer and intimation of transmission, then company is under obligation to intimate the same within 30 days from the receipt of instrument of transmission or transfer. Now afterwards, if the transferee is agreed with the same against the refusal to register the same, then may make an application before the tribunal, may make an appeal before the tribunal. Now what is the time limit of it? In case of private company, if the company is refusing to register the transfer or transmission, then time limit is transferee should make an application within a period of 30 days from the receipt of notice. And where the company has not giving receipt, not responding within a period of 30 days, then in such a case within a period of 60 days from the submission of intimation or intimation given to the company with regards to the transfer and transmission. So from that within 30 days may make an application before the tribunal. In case of public company, also the same provision, company is required to give the intimation about the same refusal within a period of 30 days. If the transfer is agreed with the same, may make an appeal before the tribunal within a period of 60 days from the receipt of notice. And in case if no notice has been received, then within a period of 90 days from the intimation made to the company with regards to the transfer and transmission. While dealing with the case, the tribunal, after going through the case and going through the documents, either dismiss the application, dismiss the appeal, or pass an order and direct the company to register the transfer or transmission, or direct the company to make the rectification in the register, and in later case may also direct the company to pay the damages incurred by the applicant. So this is provided under the Companies Act section 58.3, section 58.4. Now the rule, manner of application, but also along with the section 58, the one section, also section 59, that is corresponding section, and the manner of application is remain same for section 58 and 59. So let's go for first section 59. As we are aware about section 59, it's all about the rectification in the register of member. Without sufficient cause, if the name of member has been removed from the register, or without sufficient cause, if the company has entered of any person name as in the register of member as a member, then in such a cases, either member जिसका नाम without is holding the shares आ गया रजिस्टर मेंबर में, और एनी पर्सन जो मेंबर था और विदाउट सफिशिएंट को जिसका नाम निकाल दिया गया, और कंपनी जब दोनों पर्सन क्लेम कर रहे कि आई एम द क्लेम राइटफुल ओनर, आई एम द क्लेमफुल ओनर, राइटफुल ओनर, देन इन सच अ केस the company may also make an appeal before the tribunal, and tribunal, after producing the case, pass an order and direct the company to make the rectification to rectify the register of member, register of securities, whatever the case. And in such a cases, the tribunal also direct that company to pay the damages whatever has been incurred by the company, and whatever the order which has been given by the tribunal and direct the company should comply with the said order within of 10 days. Now, so this has been provided, this is all provided under section 58 and 59 of the Companies Act 2013. Now, corresponding rule of NCLT under which the manner of application which has been provided. Here it is little bit different. Rule 70 of the NCLT Rules 2016, which provides the manner of application in case of your case is fall under the section 58 and 59 of the Companies Act 2013. So manner of application is the same either of the case 58 or 59. The manner of application is NCLT 1. Now the supporting documents. First we are going to learn about the manner of application, then how the case is going to handle, then we will further discuss. Now, so first, in case of manner of application, the manner of application is NCLT 1 and the supporting annexures are, in case of section 58 case, refusal to register transfer. Then the supporting annexures, that would be first the company's document, registration document, whatever the case, transfer document that you have submitted to the company, the transfer documents. Third, whatever the company has given ground on which refusal has been made to that document. And fourth, why your register of transfer should get registered. So that documentary proof. Now, in case of this is refusal of transfer case, or supporting any document evidence on the basis of which you are alleging that you are the rightful, the transfer has been made in compliance with the law. So this is the case of refusal to transfer, register the transfer of shares or securities, or intimation of transmission. Now go for case of section 59. If that would be the case of section 59, then the supporting annexures, that would be you are claiming to be the rightful owner. Then in such a case, the registration document of company. Second, whatever the proof on the basis of which you are saying that you are the rightful claimant, that is share certificate. Also annual return of the previous year where your name is appearing. Also any of the benefit that has been given by the company as a member, considering as you as a member. Then if your share has been misplaced and because of that share has been transferred and you are claiming that you are the rightful owner, then in such a case if you have make an application, if you have filed an FIR, then the copy of FIR, if you give and publish a public announcement, that means by newspaper, that my shares are misplaced and all, so that copy of that advertisement, so showing as a rightful claimant. So these are the proof where you can make the supporting annexures to the application. Here the format of application is remain same, that is NCLT 1, but here the method of hearing is different. In a first hearing, after filing the application, in a first hearing, the tribunal give the direction to the appellant that to give the public announcement, to give the public advertisement in newspaper regarding the petition that you have filed at least 14 days before the next date of hearing, and direction given to serve the notice of next date of hearing to respondent. So appellant first need to require to give the public advertisement in accordance with the rule 35 of the NCLT rules, and the format is NCLT 3A. NCLT 3A. Now after giving the public announcement, that should be before the publication of newspaper, that should be before the at least 14 days of the next date of hearing, and also need to require to serve the copy of petition and notice of next date of hearing to the respondents. Now after that, in a second hearing, whatever the objections that has been raised by the interested person, after hearing them and after hearing the parties, the tribunal direct that and tribunal make an order any of the following. That is, first, pass an order as demanded, relieved. Second, pass an appropriate order. Other interim order may pass. Third, any of the other order that deem fit, ancillary order. Also, any order with regards to injunction on the right issue, bonus issue with respect to that shares, dividend. So these are matter ancillary, should be also decided by the tribunal what to do. And in case of section 59 case, the tribunal should pass an order with regards to the who is the rightful claimant, the title, which person possesses the rightful title. First, and second, ancillary order, decide ancillary matters with regards to the said shares which are in a question. So this is the case. So here it difference is that advertisement you require to give, because पब्लिकली पता चले कि अच्छा ये शेयर्स के बारे में है, तो इससे अगर मेरा राइट अगर इफेक्ट हो रहा हो, देन आई एम, बिकॉज अगर मेरे को ट्रांसफर किए गए और आप एप्लीकेशन कर रहे हो, तो इन दैट केस ऑल्सो आई शुड हैव बीन गिवन अपॉर्चुनिटी, एंड दैट्स व्हाई the advertisement is required to be given. Now, case law. यहाँ पर 3-4 केसेस है, बिकॉज सेक्शन 58 and 59 both sections are involved. So I will give you both case laws regarding both the sections. In one of the case, what happened is the one person is claiming to be the rightful owner of 4,000 shares of one company and make an application before the NCLT claiming that he is the rightful owner and contending that he has never transferred the shares from holding it, but he has made an application in the year of 2014, but accidentally when he has reviewed the annual filing of the company which has been made in the year of 2006, the company has showing that the shares which are held by him has been transferred in the year of 2006 itself to another person, and he has never transferred the said shares, and that's why he has filed an application before the NCLT claiming that he is the rightful owner of the shares. He has never transferred the shares. NCLT, without going to the case, going to the document, without going into the depth, reject the application. Why? This is important. Here it should be learned that it is a sensitive sections of section 58 and 59. Why? Because under the section 58, there is a time limit to make an appeal before the tribunal, that is 30, 60, 60, 90. But in case of section 59, even there is no specific time limit which has been prescribed under section 59, and in such a case, the Limitation Act will be prevail. And in the Limitation Act, the period of 3 years has been specified. And in this case, the application is made in the year of 2014 regarding to the cause of action which has arisen in 2006. So without going to the case, NCLT has rejected the case on the basis of limitation ground. So even that person is rightful claimant, he is right, but because of limitation, his right vain. So that is the important sense of section and limitation period. Another case, this is important one, थोड़ा ट्विस्टिंग वाला केस है. कंपल्सरी कन्वर्टेबल डिबेंचर होल्डर्स आर देयर जिन्होंने प्रमोटर्स के साथ एक इन्वेस्टमेंट एग्रीमेंट साइन किया और जिसके तहत उन्होंने कंपल्सरी कन्वर्टेबल डिबेंचर्स सब्सक्राइब किए, एंड बिकॉज ऑफ दैट द अल्टरेशन हैज बीन मेड इन द आर्टिकल्स दैट कि on the receipt of notice from the compulsory convertible debentures, the company will issue the equity shares within 14 days. So, on such a ground and on such a terms, the compulsory convertible debentures are issued. In the midway, the compulsory convertible debenture holders, some of the debenture holders have given the notice that they want to convert their debentures into equity. The promoters are refusing, and in that interregnum, the promoters and company, there is a inter-se litigation between the promoters and company, and they move before the tribunal and take the stay on the general meeting, where the approval of the issue of shares in replace of the compulsory convertible debentures is proposed to be passed and get the adjournment on the same AGM, and also they have contended that the board meeting is having no such quorum, and that's why as a result of no such proper board meetings, we are on that reason they are refusing to convert the debentures into the equity. So that's why the compulsory convertible debentures holders have moved before the NCLT under section 59, stating that they are the rightful claimant, because at the time of terms of issue they have already mentioned and the promoters are already agreed, and accordingly the articles has been entered, in which the company has contended that there is a lots of question arising with regards to the interpretation of clause of articles, of clause of investment agreement, and also the compulsory convertible debenture holders have made an application before under the IBC, and also the case is also pending before the arbitrator, and that's why this is the case of interpretation. So NCLT does not take into further consideration and leave up to the arbitrator and decide first, then will decide. On such a ground, NCLT dismissed the application. Agreed with the decision, CCD holders have made an appeal before the NCLT. NCLT stating that NCLT has clarified that with regards to the interpretation question and which is connected to the title of the person, NCLT is exclusive jurisdiction to decide such a cases, because under section 59 it is clearly specified that the NCLT may pass an order ancillary to the title, to the question which is raised arising with the title of any person. So NCLT is an exclusive jurisdiction, and NCLT may decide the ancillary matters which pertains to interpretation which are connected to the title of person of rightful claimant. So NCLT is exclusive jurisdiction, and that's why after hearing the case, action has been given to the promoters and company. They need to issue the equity shares against the compulsory convertible debentures, and should their name rectify the register and should make their names available in the register of member. Another case, refusal. Here there is both the case regarding the section 59, the case of section 58. In one of the case, the shareholder who is willing to transfer the shares, and for that he has entered into the transfer date, share transfer forms along with original share certificates, all these relevant documents after arranging submitted to the company. The company has given the notice stating that the share transfer stamps are missing, which is prerequisites, and issue the notice to the transferee. The transferee, in response to which the transferee along with all the transfer forms and documents, share transfer fee stamps affixed after affixation, that submitted to the company. But at the time of submission, the transferee has forgot to submit the original share certificate along with the transfer, and that's why the company has refused to register transfer now, and stating that the transferee has not submitted the original share certificate, and also the stamps which are share transfer stamps which are affixed, that have not cancelled, and that's why the company is refusing to register the transfer of shares. Agreed with the decision, the shareholder, the transferee, moved before the tribunal and contended that the transferee has further submitted the share certificate to the company, and so after going through the case, the NCLT has observed that the query which has been raised by the company with regards to share certificate that has been afterwards submitted to the company, and the query with regards to the share transfer stamp, cancellation of the share transfer stamp, so company should not go into so much of technicality, because they can also cancel the same. So on so much of technicality, the company cannot reject the share transfer stamp and refuse to register. They can also give an again chance to the shareholder to rectify the same, but can't refuse on such technicality grounds. The last case law, where a person has filed a case before the NCLT and contending that he is a rightful claimant of 12,000 shares, out of which 8,000 as a nominee of the deceased member and 4,000 he has acquired through transfer, against which company has contended that out of the 8,000 which he is claiming as a nominee of the deceased shareholders, in which he is a guardian of the nominee of the deceased shareholder, which is a minor daughter, and also before deceased the shareholder has changed the guardian, so now he is not rightful claimant. And in second, the 4,000 shares the company has transferred mistakenly to another person, and that's why the direction has been given with regards to the 4,000 only shares to rectify the register and enter his name in the register of member. So here that can be the case of section, which is fit case of section 58-59. Also sometimes it happens that someone has misplaced the shares and the person who has found that shares fraudulently by inspecting the register of member, verify aware about the sign of that said shareholder, and by forging the sign he has transferred the shares and getting the consideration, and further to transfer the shares to another person, the transfer that another, and after sometimes the rightful claimant come to know that his name has been removed from the register member, and then after that he inquiring with the company, he has found out that his shares already transferred and where his sign is already there, on which he has never been signed. So this chain after that arisen. So this can be the cases of section 58 and section 59. Now for this time that's it, but आगे और भी है, because आगे आएगा 60-1 के where there is a government given order for conversion of loan and debentures into the equity, where consolidation division 61, आगे power of tribunal to call the EGM, so मिनट्स इंस्पेक्शन के लिए मना कर रहे हो, कंपनी मना करेगी तो तब भी आप कर सकते हो, इंक्वायरी इंस्पेक्शन, ऑपरेशन मिसमैनेजमेंट. So the another video will be there. So till that time, stay connected, and if you like this video, then don't forget to watch and don't forget to like and subscribe my channel. So till that time, stay happy, stay connected, and stay safe. Goodbye.